And so we begin with the subpoena from the January 6th committee ordering Donald Trump to testify under oath and provide documents.
The former president's legal team reacting overnight to the historic move.
ABC's White House correspondent Mary Alice Parks is on Capitol Hill with the latest on the potential legal battle brewing. Good morning, Mary Alice.
Eva, good morning. The January 6th committee voted unanimously last week to take this extraordinary step, and now they have done it. They wrote that the former president personally orchestrated and oversaw an entire effort to overturn the 2020 election, and now he needs to answer for that. This morning, former President Trump waking up under deadline, now formally subpoenaed by the January 6th congressional committee.
A subpoena to a former president is a serious and extraordinary action.
On February 28, 2025, a visual symbol of a years-long legal saga played out on the tarmac of Joint Base Andrews. As Air Force One prepared for a flight to Florida, workers loaded several boxes onto the aircraft, the same boxes that had been at the heart of a federal criminal investigation. President Trump issued a simple statement: "The Department of Justice has just returned the boxes." This moment marked the formal end of a conflict between the power of a congressional subpoena and the unique protections of the American presidency. Today, we break down how we got here, why federal cases against a sitting president evaporate, and what this means for the future of government oversight. Let's play this clip.
Start with the next steps for the former president. Given his legal options, how likely is it that we're actually going to see him testify?
Whit, I would say it is unlikely, but not impossible. So we all know that former President Trump loves an audience, right? And the January 6th committee has been, well rated. People have really tuned in. So I am sure he will be tempted to actually respond to the subpoena by agreeing to appear and testify publicly. But at the end of the day, I think the legal risk for him is just too great. So if he's listening to the advice of his lawyers, he won't at the end of the day agree to show up and testify. Testifying opens up the possibility of perjury charges, and he is already facing a number of serious criminal investigations, including the one growing out of the Mar-a-Lago classified documents. So I don't think at the end of the day it happens, but, he may keep us in suspense about it.
The closing chapter of the federal investigations into Donald Trump began not in a courtroom, but with a series of quiet administrative moves following the 2024 election. To understand how thousands of documents and multiple felony counts simply vanished from the legal calendar, we have to look at the intersection of Department of Justice policy and the high bar of presidential immunity. On January 7, 2025, Special Counsel Jack Smith submitted his final 2-volume report to the Attorney General and resigned from his post just 3 days later. His departure was the result of a long-standing Justice Department policy that prohibits the federal indictment or prosecution of a sitting president. Smith himself wrote that this prohibition is categorical and does not depend on the gravity of the crimes charged or the strength of the government's proof. In the eyes of the law, the moment Donald Trump was inaugurated for a second term, the federal cases against him reached a constitutional dead end. But the story of these boxes and the subpoenas that chased them is one of the most complex legal narratives in our nation's history. It is a story about the power of inquiry, an essential legislative function that allows Congress to oversee the implementation of existing laws and evaluate the need for new ones. The Supreme Court has long held that this power is an essential and appropriate auxiliary to the legislative function, noting that a legislative body cannot legislate wisely or effectively without information. When the executive branch resists these requests, Congress turns to the subpoena, a constitutionally based demand for information. A recipient of a valid congressional subpoena has a legal obligation to comply unless a valid and overriding privilege permits noncompliance. However, as the last few years have demonstrated, a subpoena is only as effective as the means by which it is enforced. For most of American history, Congress relied on what is known as inherent contempt to enforce its demands. This is a dormant but still valid power that allows either the House or the Senate to unilaterally authorize its sergeant-at-arms to arrest and detain individuals who obstruct the work of the legislature. While this power hasn't been fully exercised since the 1930s, its existence remains a shadow over every oversight dispute. In modern times, Congress has instead leaned on two other methods: criminal contempt referrals to the Department of Justice and civil enforcement lawsuits in federal court. The effectiveness of these methods depends entirely on who is being targeted. We saw this play out with starkly different results for Donald Trump's allies compared to the president himself. Steve Bannon and Peter Navarro, both former White House officials, refused to comply with subpoenas from the House Select Committee investigating the January 6th attack. Because they were private citizens at the time of their defiance, they were referred for criminal contempt, prosecuted by the Justice Department, convicted by federal juries, and sentenced to 4 months in prison. Their cases proved that for normal citizens, a subpoena carries the weight of the law and the threat of a jail cell. But for a president, the rules are fundamentally different. When a president directs an official not to comply with a subpoena citing executive privilege, the threat of a criminal contempt prosecution often becomes unavailing. The executive branch has long asserted that the criminal contempt statute was not intended to apply to an official who asserts a claim of executive privilege at the president's direction. This created a scenario where, throughout his first term and his post-presidency, Donald Trump was able to fight subpoenas through years of slow-moving litigation rather than facing the immediate arrest that many YouTube creators falsely promised their audiences. The most significant battle over these documents centered on the Mar-a-Lago estate in Florida. The timeline began in early 2021 when the National Archives and Records Administration, or NARA, realized that several high-profile items were missing from the transition of records, including correspondence from North Korean leader Kim Jong-un and an original altered Hurricane Dorian map. The Presidential Records Act is clear. These materials belong to the United States and must be surrendered to the archivist at the end of a president's term. For nearly a year, NARA engaged in what they described as extended negotiations to retrieve these items. In January 2022, Trump voluntarily surrendered 15 boxes, but archivists were alarmed to find that these boxes contained 184 unique documents with classification markings, including 25 documents marked top secret. This discovery triggered a criminal referral to the Department of Justice. On May 11, 2022, the DOJ issued a grand jury subpoena for all documents bearing classification markings. This is where the narrative becomes a matter of documented movement and surveillance. According to the federal indictment between May 23 and June 2, 2022, a Trump employee named Walt Nauta allegedly moved 64 boxes out of a storage room and into the residence, often just before legal counsel arrived to search for subpoenaed material. On June 3, 2022, Trump's attorneys handed over 38 additional classified documents and signed a declaration attesting that a diligent search had been conducted and all classified material had been returned. However, the Justice Department, aided by an informant and surveillance footage, came to believe that more documents remained on the premises. This led to the unprecedented event of August 8, 2022, when FBI agents executed a search warrant at Mar-a-Lago. The warrant was based on 3 federal criminal statutes: the Espionage Act regarding the unauthorized retention of national defense information, the destruction or concealment of records to impede an investigation, and the illegal removal of government records. During that single-day search, agents seized over 13,000 government documents, including 103 documents with classified markings, some of which were found in a desk drawer in the former president's office. The legal fallout was immediate and intense. In June 2023, a grand jury in Miami indicted Donald Trump on 37 felony counts. The charges included 31 counts of willful retention of national defense information under the Espionage Act. The government alleged that these documents contained nuclear-related information and sensitive data from the CIA, FBI, and NSA. Trump pleaded not guilty to all charges, and his legal team argued that as president, he had the absolute authority to declassify documents. While Trump claimed he had issued a standing order that anything he took home was automatically declassified, the Department of Justice reported they could find no record of such an order, and several former administration officials labeled the claim a complete fiction. For over a year, the case was overseen by District Judge Aileen Cannon, a Trump appointee whose rulings often drew scrutiny from legal observers. On July 15, 2024, Judge Cannon took the extraordinary step of dismissing the entire classified documents prosecution. She sided with the former president's argument that the appointment of Special Counsel Jack Smith was unconstitutional. While the special counsel's office initially appealed this dismissal, the political reality of the 2024 election fundamentally changed the legal landscape. The Department of Justice operates under the Take Care Clause of the Constitution, which directs the president to ensure that the laws are faithfully executed. This gives the executive branch broad prosecutorial discretion to decide which cases to pursue. In the context of a sitting president, this discretion is effectively total. Following the election, the Justice Department determined that its prior opinions regarding the prohibition of prosecuting a sitting president applied to this situation. On November 25, 2024, Judge Tanya Chutkan approved the request to dismiss the separate election obstruction case in Washington, D.C., and the appeal of the documents case was similarly dropped. The return of the boxes in February 2025 was the final punctuation mark on this era of litigation. White House officials described the contents of the returned boxes as personal items, though the years of investigation suggested a much more complicated mixture of presidential records and sensitive data. This outcome highlights a fundamental tension in the American system of checks and balances. The framers designed our government so that different branches would work to keep each other in line, a system David Cole of the ACLU describes as one of transparency and accountability. But as Judge John Bates noted in the Mears case, the system also relies on a spirit of dynamic compromise and a realistic evaluation of the needs of conflicting branches. When that spirit of compromise fails, the burden falls upon the courts to say what the law is. However, judicial resolution is notoriously slow. In the case of the fast and furious litigation involving Attorney General Eric Holder, it took more than 6 years to reach a resolution, a delay that diminishes the value of the disclosure and the ability of Congress to conduct effective oversight. Reliance on the courts also involves the risk that a judge might issue a decision that weakens the legislative branch's investigative powers for decades to come. The special counsel's final report, released in early 2025, provides the most detailed look we may ever get into the evidence gathered during these years. Volume 1, which focused on the efforts to overturn the 2020 election, was released to the public on January 14, 2025. It suggests that the government believed its proof was strong, yet the constitutional shield of the presidency prevented that proof from ever being tested in a trial. For many Americans, this is a frustrating reality of a system that prioritizes the stability of the executive office over the immediate prosecution of its occupant. As we move forward into a new administration, the questions of executive privilege and the scope of congressional subpoenas remain largely unsettled by the Supreme Court. Each branch continues to interpret its own institutional powers in divergent ways. The executive branch views its privilege broadly, covering presidential communications and internal deliberations. Congress interprets its power of inquiry just as broadly, asserting that no person is above the law and that the eyes of the representatives must be allowed to look diligently into every affair of government. What we have learned from this saga is that while a subpoena is a powerful tool, it operates within a framework that respects the separation of powers. Instant justice and immediate arrests are the tools of viral storytelling, not the reality of American constitutional law. Real accountability moves through slow, procedural, and often boring channels, through litigation, through elections, and through the political process of impeachment. The legacy of the Jack Smith investigation will likely be debated for generations. It showed the unprecedented reach of a special counsel and the equally unprecedented resilience of presidential legal protections. As the boxes returned to Florida, they carried with them the unanswered questions of a nation still grappling with how to hold its highest leaders accountable within the finely wrought procedures of the Constitution. For now, the legal battles have paused, but the constitutional conversation about the power of the president and the rights of the people's representatives is far from over.